Pnawn da. Good afternoon. Welcome to Licensing Committee, 7th of May 2025. Please note that today's meeting may be recorded. This recording will be broadcast on the authority's website and may be used for training purposes by the Democratic Services Department. All attendees will be in view of the camera, and by attending, you are consenting to being filmed, to the possible use of these images and sound recordings being used as outlined above. Apologies for absence. There aren't any. Item number 2, declarations of interest. Members are reminded of their personal responsibility to declare any personal and prejudicial interest in respect of matters contained in this agenda in accordance with the provisions of the Local Government and Finance Act 1992 relating to council tax, the Local Government Act 2000, the Council's Constitution and Members' Code of Conduct. Please note, members are reminded that they must identify the item number and subject matter that the interest relates to and signify the nature of the personal interest, and where members withdraw from the meeting as a consequence of this disclosure of prejudicial interest, they must notify the chair when they leave. For those attending by Teams, what we intend to do is we'll introduce ourselves, and if you do the same, we'll then go on to the application. I'm Dave Isaac, Councillor for Byddaron and Galanacha.
I'm Gillian Preston, Councillor for Bedlinog and Treelewis.
Good afternoon, I'm Councillor Michelle Jones for the Cyfarth Ward.
Hi, Simon Jones. I'm a solicitor with the authority and I'm here to advise the committee.
Jo Baber, Licensing Manager for Merthyr Council.
I'm Councillor David Jones, Town Ward Councillor.
Okay, thank you. We go on to item agenda number 3, applications for a new premises licence, Domino's Unit 1, Glovenshire's House, Court Street, Merthyr Tydfil, CF478DU, to consider a report from the Director of Governance and Resource. And Jo, I believe you've taken the report.
Thank you, Chair, members. So this report is in relation to an application for a new premises licence for Domino's, Court Street, Merthyr Tydfil. The application proposes late night refreshment Monday to Sunday, 11 PM to 5 AM, and opening hours of 24 hours a day. However, the applicant has also proposed a condition that the premises shall close to the public after 2 AM and will then operate solely as a delivery service until 5 AM. And a copy of the full application and the plans can be found in Appendix A. During the statutory consultation period, representations were received from South Wales Police requesting certain conditions, a copy of which can be found in Appendix B. Representations were also received from 2 ward councillors objecting to the application, and copies of those representations are at Appendices C and D of the report. Following the end of the consultation period, the applicant has now agreed to the conditions requested by South Wales Police, and therefore they now have no objections to the licence being granted on that basis. Since publication of the report, Councillor Jones has provided additional information in the form of a petition and also a letter from a local resident, and copies of these have been circulated prior to the hearing, both to the applicant and to members present today. There's statutory guidance issued by the Home Office for licensing authorities to consider when determining applications, and Section 6 of the report highlights relevant parts of that guidance. Members must also have regard to the authority's statement of licensing policy, and Section 7 of the report details the relevant parts of such policy. In determining the application, councillors must have regard to the full licensing objectives with a view to promoting those objectives in the overall interests of the local community, and the steps available to members today are outlined in Section 2.1 of the report. Thank you, Chair.
Thank you, Jo. I'll go on to the objection raised by Councillor Jones. I'll then go on to what the applicants have to say, and we'll have questions and comments then.
Thank you, Chair. Local residents have made many representations to me since Domino's took over the old Glove and Shears public house, both historically and recently. From the number of signatures on the petition against the application, you can see that this is a serious problem for residents. This application is a serious problem for residents. The issues include delivery vehicles parking in the residential permit parking areas and blocking the road at Alma Street, sometimes for 15 minutes or longer, whilst drivers are waiting to pick up their deliveries. When the delivery vehicles are parking, the lights are shining into residents' homes, which is very distracting if they're in their living rooms, watching TV, for example. As they pull into park, many vehicles have their windows open, with music playing loudly at all times of the evening and night, upsetting residents' sleep, especially those that have got to get up for work early in the morning, those that have young children, and the elderly. Frequently, when drivers meet each other in the street, they shout across the street or the road to each other, and the language used by some of them is disgusting. Car doors are often slammed by delivery drivers through to the early hours, again causing residents to be woken by the noise. Some delivery vehicles have loud exhaust systems which also disturb residents' right to peace and quiet, with some of them racing around local streets to access the tram road, creating a safety hazard for pedestrians and dog walkers alike who walk on these narrow roads, as well as the noise issues. Residents also fear that the premises being open until 5 AM will attract people that are under the influence of alcohol or drugs to be attracted to the area, even though they should not be served after 2 AM. Residents have spoken to previous managers about these issues, and the situation does improve for a while, but then reverts back to the old ways. Residents believe that of the 4 licensing objectives, the prevention of public nuisance is not being adhered to, with there being cases for breach of protection of children from harm and public safety too. Residents are very concerned that if this application is accepted, that there will be a further deterioration in their right to enjoy peace and quiet in their own homes, and ask that no further opening hours are permitted for this business so that this can happen. Thank you, Chair.
Thank you, Councillor Jones. And we'll go to the applicants for their statement.
Questions, first of all, from the applicants on Councillor Jones's representations.
Yes, sorry. Any questions from the applicants on Councillor Jones's statement?
No, I don't have any.
No.
Yes, so as you have no questions, it's over to you.
Good afternoon,
I believe you're
councillors.
on mute.
Am I on? Am I on?
I think you're on mute now.
Right. Can you hear me now?
I can hear you.
Yeah.
Sorry,
Can
I
they
can't
not?
hear a thing at the moment.
Okay. Can you hear me?
I can hear you.
Yeah. Councillors, can you hear me? Maybe if you come off mute, if you mute yours, Nazir, that might.
If you can hear me, I can't hear you.
I can hear you. Can you hear me?
Can you log off and log back in again, please? Perhaps that will solve the problem.
Okay.
Sir, the one that's left on Teams, can you try speaking to us to see if we can hear you?
Can you hear me, councillors? Can you hear me?
Mr. Jar?
Mr. Jarges, can you hear us? Still in there.
But can you try speaking again to see? We'll try and sort it our end.
Can you hear me, councillors?
We can finally hear you. Yes.
Thank you very much. There's a lot of feedback coming back as I speak, but can you hear me okay now?
Yes, we can. Thank you.
Okay. Okay. Well, first of all, thank you very much for sorting out that technical issue, and good afternoon, first of all. My name is Waleti Rator from Licensing Law Consultancy. I am here to represent the applicant in relation to this application. Now, I want to start off by just summarising what our case is effectively, and it's simply this: that this application should be granted as applied for, but subject only to the conditions volunteered in the operating schedule and also the additional conditions agreed with the police. And we say that because there is no logical or real evidential basis for refusing the application. As you will know, we can only do what is right in law for today's purposes, and only take into account what is relevant and real and substantiated evidence. And when I say right in law, I do of course mean the Licensing Act, the statutory guidance, your own policy, and of course case law, but only where they are all consistent. The committee report has very helpfully echoed some of the key considerations for today's purposes with reference to the statutory guidance which are settled in case law. And this is where the report talks about the licensing authorities' determination
If you wait
to
one
be
second, Mr. Rator,
evidence-based.
can I stop you there? Because we are having feedback from the other applicant.
Okay.
And it's coming back and interfering with yourself. Yeah.
Okay.
Yeah. Okay. Okay. Yeah. Right. You can carry on now. They seem to have muted themselves.
Okay. I was saying, I was making reference to some of the relevant points to echo what I've already said, and that was where the report speaks about the need for licensing authorities' determination to be evidence-based and justified as being appropriate for the promotion of the licensing objectives, and of course the need to consider each application on its own merits. But why is this important? Well, for today's purposes, the correct application of the licensing regime and the relevant key provisions, considerations, will enable you to make a robust and a reasoned licensing decision which can stand up to scrutiny, rather than a decision based on speculation and irrelevant matters which would easily collapse under scrutiny. Now, the issues in this case are straightforward, but I think it would be very helpful for everyone in this room and those joining remotely to set out the background to the application and to put it into perspective. The starting point to note is that this is not an application for alcohol or regulated entertainment. It's an application for late night refreshment, which is by far considered the safest of the licensable activities. The applicant is a multi-site Domino's franchisee with around 40 stores in England and Wales. So they operate all over various regions in Wales as well as some parts of England. They employ around 1,400 employees, including area managers and also office-based staff who deal with things like admin, property, HR, licensing, etc. So the point there is it is an organised and a professional organisation who know this industry really well. And they also have several sites which have a premises licence in similar locations, and they operate very successfully into the early hours of the morning and without any unnecessary onerous conditions. The operators have internal procedures backed by a management plan, and that includes things like closing the front of the store when it operates for deliveries only and turning off signage, lighting, etc. And this is designed to prevent people congregating outside. The staff and drivers are also instructed to work in a respectful and quiet manner. And they have been successful, and the reason for that is because they do have a good relationship with the responsible authorities, a good working relationship, and a proven track record in this industry. And they wouldn't have been that successful either if they didn't maintain good working relations with the residents too. Talking of the responsible authorities, this has already been touched upon during the presentation by your licensing officer, but as part of the application process, we cooperated with the police in the spirit of working in partnership and reached a neat agreement with them to alleviate their concerns, and you will have seen details of that in the hearing papers. You will have also seen that the police attended and discussed the matter with the manager at the site before liaising with us further, and the police simply had no issues with the hours applied for. And they were generally happy with the conditions which were volunteered by the applicant to promote the licensing objectives, and all they simply wanted was the wording for some of those conditions to be modified, and for 2 extra conditions which they felt were necessary to promote the prevention of public nuisance licensing objective, and as you know, the applicant agreed to those without any issue. The key point of all this is, as you'll be aware, the police are recognised as the main source of advice and expertise on matters concerning crime and disorder, who are, as I say, in support of this application and are satisfied that the licensing objectives will not be undermined. In fact, the police concerned themselves with all the 4 licensing objectives and stated the following in their representations, and it's worth just reading this out, and I quote: "The police believe that the recommended conditions are relevant to this application, having considered the individual style, character and location of the premises, and having taken into account the details supplied by the applicant." And they go on to say the police consider the conditions as being just, proportionate and necessary to promote the licensing objectives. It is perhaps more significant, and certainly equally significant, that the Environmental Health Department has not made a representation, and they are, of course, the responsible authority responsible for the licensing objectives that we are mainly concerned with for today's purposes, and that should be given significant weight. So the main authorities and experts have considered this application and have decided they have no issues with this application being granted subject to the agreed conditions. And this is perhaps not surprising, as we have never received any direct complaints or been advised of any complaints being registered with the authorities. And we find it strange that a statement has been made today about complaints to being made with the councillor when there has been no record of any complaints registered with the environmental health officer at the council, to the point where they did not even make any representations or any comments in relation to this application. And that is curious, to say the least. And then that does bring me on to the residents. And as I say, there were no representations from the residents. And therefore, just to put that into perspective, there has not been a complaint against these premises whatsoever that's been directed, either direct to the premises or with the council. The application was submitted in February, and we heard nothing from the residents during the consultation period, and we still haven't heard anything direct from them of any substance to influence your licensing decision. So then that brings me on to the two councillors' representations, and the first one I will deal with is from Councillor Thomas. He states that he has no objection with a closing time of 2 a.m., which is sensible based on the evidence or lack of, but he then strays into very dangerous territories of speculation and irrelevant matters. And he starts by stating, and I quote, I personally, my concern is the delivery of time up until 5 a.m. Well, as you are aware, councillors, personal concerns of a councillor without evidence are irrelevant and inappropriate for today's purposes. The councillor is not an expert to make such a statement, and little, if any, weight should be given to it. He also states, and I quote, I honestly don't see the need for this. Well, that's a non-starter. As you will know, the guidance and law is clear on this point. Need is not a relevant consideration for today's purposes. And then the remainder of the representation, I don't propose to go into that in detail, because it quite clearly is based on pure speculation and also based on irrelevant matters such as highways and traffic issues. Then moving on to Councillor Jones' representation, that also suffers from and fails on the same basis as I've already set out for the previous councillor. It is simply speculation based and consists of irrelevant matters. We already know that there have never been any resident complaints against these premises. No evidence of that before you today. No direct evidence, and we also know that there have been no representations received from any of the residents since the application was submitted in February. But then we received, produced by Councillor Jones, a petition and a letter 1 week before the hearing, almost 3 months after the application was submitted, to support what we say is speculation-based representation. In terms of the petition, in these circumstances, it should be treated with extreme caution as having any evidential value, if at all. I appreciate we can have hearsay evidence, but the weight to be given to it is still to be determined, and very little weight should be given to it. And the reason for that is that the narrative used in the petition is also flawed, as it is clearly based on speculation without any real evidence to substantiate the assertions, as well as being based on irrelevant matters. So there's a common theme here. And I would say it all seems like a desperate and a last-minute attempt to drum up signatures in a misguided attempt to show substance which does not exist. collecting a list of signatures cannot elevate speculation to the status of evidence. And when we look at this petition, it can be very easy to be persuaded by the number of the signatures present, but we must look at what the residents are actually signing and whether that in and of itself carries any weight. The narrative to the petition is littered with a number of unknown and irrelevant matters, which I've already alluded to, such as highways and speculation about what the later hours might bring. Therefore, what we actually have is a number of signatures all agreeing to an unqualified and unsubstantiated view. And this fails miserably at attempting to pose as evidence and is simply not enough to influence a licensing decision. And it's entirely irrelevant whether there's one signature or 50 or 100 to this petition if the narrative of the petition is deficient from an evidential perspective. And then moving on to the list of car registrations, I'm baffled as to what this is. Most of it is redacted, but just by calling something evidence does not become evidence. The councillor has produced a document which lists car registrations, which we can't see for a start, but even if we could, what they say is that this is evidence of illegal parked cars. How can a list of registrations show or prove that that's illegally parked cars? That is simply nonsensical. Then it states that this shows the volume of slammed doors, etc., that could be expected. No, it does not. It would be absurd to suggest that this is evidence to support speculation-based assertions. There's no scientific evidence here. Then there is more speculation-based comments regarding litter and random comments about noise decibels. So taking all that into account, there is no evidence of any registered complaints, no evidence of any premises-specific issues, and no appreciation of the balance that will be created by the conditions volunteered and agreed with the responsible authorities. And that, as I say, is simply not enough to influence a licensing determination, because that would be grossly unjustified, inappropriate, and disproportionate. Now, we appreciate the licensing objectives are phrased using the word prevention of a crime and disorder, public nuisance, but the reality is there still needs to be some real substantiated evidence. Otherwise, it will be impossible for the grant of any application to promote the licensing objectives. You will also know, and I'm certain your legal advisor will certainly know from the Thwaites case, that where representations challenge the view of the responsible authorities who are in support of this application, then there is a need for an extra level of real evidence to support their viewing case. Here, there is nothing whatsoever of any evidential value to influence your decision making, let alone any extra level. Councillors, that's all I wish to say in opening our case. If there are any questions, then please feel free to ask. Thank you.
Thank you for that. I will go to the committee in asking, are there any questions?
Good afternoon, everyone. First of all, can I just check the licensing hours at the moment are 11 AM to 12 AM most days, and then 1 AM on Saturday. Is that correct? I've had to take that off the website, so I just wanted to check.
Sorry, I missed the first part of
That's
the
okay.
question. Sorry.
So,
Councillor.
at the moment, what time is Domino's able to be open?
It isn't licensed by us because it doesn't sell alcohol. So the only licensable activity that they would carry out is late night refreshment. Late night refreshment only becomes licensable between the hours of 11 p.m. and 5 a.m.
Oh,
So
okay.
the serving of hot food and drink outside of those times, they don't need a license from us. That's why this application has come in, because they want to carry out licensable activity now.
Right, okay. Because on the website it says that they're open till midnight and open till 1 a.m. on a Saturday. So should they not be serving food then at those
No.
times? Okay, so can the applicant confirm then, are you breaking rules at the moment?
As far as I'm aware, I'm not aware of what they operate in at this stage. As far as we are aware, they are abiding with the rules and the regulations, and also I don't think any issues have been raised regarding any illegal trading at this site.
Could the applicant answer that question for me then, please?
I don't know if he can hear you.
Hello?
Hi, we can hear you now.
Oh, you can hear. Okay. Yeah, as far as we are aware, is licensing is whatever is stated on the license at the moment. I guess is between 11 and 11, as far as I know. But personally, I don't deal with that kind of thing because it's something for our head of operations. They deal with opening hours. As far as we're concerned, it's just we needed to extend these hours from 2 till 5 for deliveries.
Okay. Okay, that's it for now, thanks.
Okay, thanks. You've said in your application that there are no problems with the highways. The staff you have delivering, where do they park whilst picking up? And wouldn't this cause a hazard to the highway if they are parked on double yellow lines, etc., and in junctions? As you said, you don't believe so, but from what we've been told, they are parking in junctions. Can you answer that?
Yes, Chair, if I can assist with that, in our presentation, what we were saying that the highways issues are irrelevant for licensing purposes for today's purposes, and that there wasn't any actual evidence of the assertions that have been made. Even if there were, they are matters that are outside the remit of your decision making today. So that was the point we were making. And also we were saying that presenting a list of registrations is not in and of itself evidence of illegal parking. There isn't actual any evidence. There's just statements being made. There isn't, for example, videos showing that, and also there is nothing to say that any illegal parking, if you can call it that, is just the drivers of Domino's and not just sort of the general sort of public, if you like. So the point there is, the assertion has been made there's illegal parking, but there isn't any evidence to show that. Even if there was, there's still a decision to be made whether or not that's relevant for today's purposes anyway. But we can answer the second part of your answer to say where they do actually park, if that were to alleviate some of your concerns, despite whether or not this is relevant or not. And I'll pass that on to the company representative. Thank you.
Thank you for that. If you wouldn't mind doing that, then.
Chair, just from my point of view, obviously the parking situation isn't relevant in relation to licensing. However, it becomes relevant if you think there's a public safety issue from the parking. So I think there is some relevance for licensing, albeit just saying that there's parking concerns blocking up the street. That wouldn't be a licensing issue.
Okay, thank you for that. Jill's got a question. Councillor Preston.
Yeah, good afternoon. I wonder if you could tell me the other Domino premises, are they in residential areas?
Yes, they are. I have about 3 or 4 clients which between them have about 300 Domino stores in every type of location you can think of. As I said in my presentation, for this particular applicant, we have about 40 in residential areas with arguably in more sensitive areas, i.e. premises where you've got residents to the left, right and above as well, who have late night trading without any issues. Similar to this case, we have occasionally objections to applications from residents, which we don't have in this case. And then what tends to happen is after the application is granted, they've had their say, and then they all sort of, get along, for want of a better phrase, successfully without any issues moving forward once the application has been granted. So yes, this is not unique in our portfolio of premises.
Okay, thank you.
Can I ask another question, please? It's in regards to residents' concerns, in regards to litter, especially. So do you, as a company, do anything to help with community activities? For example, the likes of McDonald's will do litter picks in the surrounding areas. Is this something that you do or would consider doing? Because obviously some of the residents' concerns are around the amount of litter that's left that attracts vermin to the area. So is this something that you could do or already do?
Yeah, I'm just trying to be careful that I'm not too dismissive of your concerns here, and I do want to answer these questions, but hopefully your legal advisor will assist me or at least confirm this. We haven't actually, what we're saying is the evidence isn't actually there. We've not heard from any residents at all as part of this process, apart from some signatures on a petition, and that's questionable as well. So, a litter, noise nuisance, or a two-stage process, you have to establish there's a problem first before you solve it. I don't think we're there yet. But having said that, of course, if there's something that we can do that's reasonably straightforward to assist with any problems that may arise in the future as a result of this application being granted, yes, we would do that.
Yes, thank you. I'll call on Ward Councillor Jones.
Thank you, Chair. Thank you, Mr. Rathore. In your presentation, you mentioned a good working relationship with local authorities and residents. Well, when 150 or so local residents sign a petition, I don't see that as being a good working relationship with the company, who've been there for quite a while. That is a bit bemusing to me. And when you're talking about the parking in the area, the area opposite the business is residential permit parking. No other vehicles should be parking there. So, and all right, I'm representing the residents, but are you telling me that they're all misrepresenting what they're seeing?
I'm not sure that's what we are saying, Councillor. First of all, you made 3 points there, broadly speaking. Is there a question in any of the previous ones at all? If you phrase it as a question, I may be able to assist you.
Well, why do you suggest residents have signed the objection?
Sorry, could you please repeat that?
Why do you suggest residents have signed this objection if there are no issues?
Well, let's take this one step back. First of all, in our presentation, we spoke about a good relationship with the responsible authorities and residents across our portfolio, which is why we have been trading successfully. Then, as part of our presentation, we stated the fact that no residents have ever recorded a complaint against the authorities, which was curious. If there were these issues, no resident whatsoever made a representation against this application, and we did not hear from them for almost 3 months, and all we have is a petition with signatures on it, and we need to treat that carefully from an evidential perspective for the reasons which I have already stated in the presentation.
The fact that you're stating that no representation has been made to the local authority, I can assure you it has, and it was made through our parking wardens with vehicles blocking up the bottom of Alma Street. And
Okay,
our wardens have been there out of hours as well, and on weekends because of the issues faced by local residents.
Okay, first of all, there's 2 points here. First of all, you're introducing new material, which there is no evidence of anyway before this subcommittee, and it's certainly not in the agenda. And secondly, I would like to call in the licensing officer, who will be able to confirm to you as an independent person that no representations have been made by any of the residents in relation to this application.
So, Councillor Jones's representation state that it is on behalf of the residents. The residents haven't made individual representations, but Councillor Jones's representations do state that it's on behalf of residents.
But I know for a fact that representation on behalf of residents, I have contacted the traffic wardens that operate for the other local authority. It's not mentioned, because until you brought it up now, it wasn't an issue.
Sorry, is there a question there?
So is it okay to say something?
Yes, you can say something.
Yeah, we have as a procedure, you can call it, if anybody of members of the public or EHO, anybody else come to us to the store making a complaint about a particular individual, we certainly take this matter very seriously. First of all, we investigate it, but it have to be based on evidence. We'll bring the person involved if there's any such an issue. We interview him, and if it's transpired to be true, we give him a verbal warning to start with. The next step, if this occurs with regard to playing music or slamming doors or irritating members of the public, we call them into our office, to our HR, in which case, if that proved to be true, we give him a written warning. Subsequent to that, if that person persists with this activity, we'll have to dismiss him. But having said that, as far as I know, but I'm not head of operation or in HR, I haven't, for this particular site, I haven't heard anything to suggest that there was an issue with any particular members of staff. So I'm not sure. I mean, sometimes you could say somebody went to the store and spoke to the manager, and the manager didn't relate back to us, but this is very highly unlikely, because they will say something, and we have all evidence, we have all CCTV in the operation all the time, so we can determine if this what happened is true or not anyway. But if it's, as I said, if it's been persisted with this kind of behavior, eventually it leads to dismissal. Obviously, we don't tolerate that kind of thing. I mean, from our perspective, we like to make everybody happy in the residence, and if somebody is unhappy, we'll be glad to hear of it.
Mr. Jarges, can I ask a question? Obviously, you
Sure.
say you've got you take these. If anyone complains, you take complaints seriously, but based on evidence. I suppose a lot of what you will be told by residents is somebody slammed a door. They may not know who that person is at the time. They're obviously not going to be able to record that on a camera, because your cameras are only going to cover the immediate area outside the premises. They won't cover the street. I think we're talking the street across the road. I wouldn't have thought the cameras are going to cover the streets there. So how would you deal with somebody who comes in and says, I was in bed last night across the road there, and one of your drivers slammed a door? I suppose the trouble you've got there is you're not going to know which driver it is. Would you be looking to send out something to all your drivers in that instance to try and ensure it doesn't happen again?
Yeah, I mean, by all means. I mean, if, for example, let's say this happened in, say, 1 o'clock or 12 o'clock at midnight, and the person obviously is not going to come into the store to report it that day. They're going to come in the following day or the day after. So we can determine who was responsible for that action, and then we'll have some sort of investigation to look into it. So we'll ask the manager, or we have head of operations, we have area managers, we have a manager at the store, we have assistant manager, and we have a shift runner. So all these people can report back to us what's happened. So, for example, I'll ask the question. Unfortunately, it doesn't come to me because I'm not responsible for that department. But they'll come to our HR and they say, well, somebody at that particular time slammed the door or shone a light or was talking or driving the car. So we could determine who would have been at that particular. They say, for example, 12 o'clock. We know the delivery was for that time. It's this particular driver. So we can call them in and investigate this issue. We always take this shit seriously anyway. And if you prove it, maybe some people, I mean, we do a lot of training with the staff and drivers in particular, and they have to pass certain criteria before they can work for Domino's. So this continuous training arrangement with us. So hopefully that will mitigate any issues like that. But then, as you said, this could happen. I'm not saying it never happens. Obviously it does, because a lot of the drivers are quite young. So we have to educate them. And again, if this persists, it will eventually, the third time, leads to dismissal if you can prove it. But obviously, at this day and age, you have to prove the culprits. You can't just say to them, "Oh, you're dismissed because somebody made an allegation against you."
Okay. Chair, I've got a follow-on question. It's not related really, but what's your busiest hour in a normal Domino's restaurant? Well, not normal. Let's say the Merthyr Tydfil branch. What's your busiest hours?
I would say between 6 and 8 or 9, something like that.
6 to 9, and then I take it then that as the evening goes on, it drops off. Is that correct?
Yes, it does.
How much of a drop off in trade will there be, say, from the hours you're looking at compared to peak hours?
As I said, I'm head of property and projects, so I deal with all projects for Domino's. I don't really deal with specifics of what time. But if it's common sense, says to me, it'll drop off by, I don't know, maybe 50%, something like that. But don't quote me on that because I'm not 100% sure.
Okay. Thank you.
Thank you. So my thoughts on this at the moment is obviously you're already operating till quite late in the evening, whether that's 11 or 12 a.m. So you're already operating till late. So would these extra couple of hours have a massive impact? This is something that I'm having to think about. And also as well, obviously Domino's is placed very close to the Labour Club, where that premises is by nature a loud premises due to parties, loud music. When they're cleaning up after the revellers, for want of a better word, have left, then obviously that can be quite noisy with emptying of bins, etc., etc. So people leaving there, they may have rubbish that they disregard. So I don't think that all of the residents that have complained can just solely blame all the noise, all of the rubbish on just Domino's. So I just wanted to ask Joe, do you have any kind of complaints come into yourself due to perhaps that area of where the Labour Club and where Domino's is, or is that not something that would come to you?
Yeah, we don't have any, but they would tend to go to environmental health, those sort of complaints, rather than to licensing anyway.
So do you have any kind of information from environmental health? Did they give us any objections at all?
They didn't, no.
Okay, thank you. Thank you, Chair.
And I'll go back to Councillor Jones.
Thank you very much, Chair. Mr. Georges, delighted to hear that the process that you've got for dealing with your errant drivers, but as I said earlier on, the area directly opposite Domino's is a residential permit parking area where people pay for the privilege to park in their houses. So from that point, will you contact all of your drivers at the Merthyr Tydfil branch and tell them that they cannot park in that area where residents have to pay for parking, please?
Of course, we can do that by all means. I mean, we can instruct them after this hearing, depending on obviously the license outcome, to refrain from if they're doing this, because for some reason I don't understand why they would do that, because we have ample parking at the back of the store anyway. So I don't know, there's like about 6 or 7 parking spaces as far as I know. But if they do that, and somebody we'll obviously mention that to them and tell them not to park in that area you're referring to. But if anybody got any evidence of that, and they can take a picture of the car or a number plate or anything like that, it'll help us as well to mitigate this occurrence if it does happen. Yeah, of course, by all means, we do that, no problem.
Thank you very much for that. But on the point of evidence, I actually live at the top of the hill where Domino's in Merthyr is. And very often you see people crossing the road who've parked in that area with the keep it hot bags. I don't know what they're called.
Hot bags?
Yeah, to keep the pizzas hot. And I drive up and down there regularly, and I regularly see people who are parked there and are obviously going to Domino's Pizza.
Sorry, are you referring to the drivers or customers?
Drivers. Well, with the hot bags, drivers.
So the drivers taking hot bag, because I don't really know the area that well. Are you saying, so if you go up the hill to the right of Domino's, is that the area we're looking at?
Yeah, I live at the top of that hill.
At the top,
So
because the parking area is right behind.
Yes, I know the area on Tram Road Side South.
Yes.
I'm born and bred in the area.
Okay.
But I still see plenty of drivers parking at the bottom of Alma Street, Pencoica. Like I said, I'm born and bred in the area, and I know for a fact that that is a residential paid parking zone. Okay.
By all means, as I said earlier, if you can take a photograph of the car to identify, so you can identify who the driver is after telling them, at no time you can park there illegally. I mean, sometimes, like with Amazon, that they just come in, park double parking and things like that just to drop something. So I don't know, maybe that's happened. But if it happened and you see it, or any of your constituents see that, please let us know. Just provide us with some evidence, and we'll take it from there.
No problem at all, Mr. Georges. Thank you very much.
No problem. Thank you.
Thank you. Councillors, got any further comments? Well, questions? No. Simon, have you got anything further?
Chair, just one thing, because I think I need to put it out there, because obviously Mr. Rathone mentioned the Thwaites case, which you probably won't have come across yet, Chair. But I've got a summary up here. It's a very well-known licensing case, and what Mr. Rathone says is quite right. I mean, you should be basing any decision on evidence. But what case law says, in particular this Thwaites case, says that it says this case is sometimes misconstrued as requiring decisions to be based on real evidence, which is what Mr. Rathone said, and the conditions cannot be imposed until problems have actually occurred. It says this is wrong. The purpose of the Act is to prevent problems from happening. and decisions can and should be based on well-informed common sense. So if you had, for instance, a little country lane, quiet, and somebody opened a nightclub at the end there, then it's common sense that there's going to be problems with people coming back and forth, increased traffic, etc., even if those problems have never ever happened. So I think there's got to be some kind of weight given to what we have heard, albeit I accept what Mr. Rathone says, is that ideally you want hard evidence. But in this case, we're trying to prove something that hasn't happened yet in some respects. It's people's concerns, isn't it? That's where, I mean, it's very easy when somebody's got a license for a set period of time, and you can say in that set period of time, these problems have occurred. Police have evidence that EHOs have evidences and residents have. In this case, of course, we haven't got that because the premises hasn't been opened at that time. We haven't got evidence from the police other than what we've already seen in their representation, which has been addressed. We've got nothing from EHOs, but I think we can take some weight from the petition and from what we've heard from Councillor Jones, albeit I think the parking issues, they are in relation to what the parking wardens have said. That's new evidence. I think we can disregard that, but I think there is some common sense in that there's a parking area across the road from this premises, and they're saying there's been problems, albeit we haven't got hard evidence, but I think there's some weight you can give. Mr. Rathone, that's what I'm going to be advised in the committee. I do accept what you're saying, that we do need evidence as well, that it can't be on pure speculation, but when there is some common sense involved, we can take that into account. Okay?
Yeah, I mean, I think we'll have to. I hear where you're coming from. We're not going to turn this into a discussion about the ins and outs of the Thwaites case. I'll take your point to an extent, and some of those examples that you've given, I can take those to some extent as well. But these are premises, as you rightly said, in a way they are not. In a way, this is not a brand new application like you would have with a nightclub, for example, because this is late night refreshment. So they have effectively, even though they don't need it, got a license till 11 o'clock. So they could have been a substantiated evidence of problems up until that point. So effectively, what we're saying is, even though you don't need a license till 11 o'clock, if you look at it, comparing it to premises that you need, they have got a license till 11 o'clock, if that makes sense. Now, so up until 11 o'clock, we have a situation where the residents have not produced anything of any substance. So that is a proxy for saying, if it's okay up until that point, because there's no evidence to the contrary, then there's nothing to say that the problems or the lack of them wouldn't continue into the later hours anyway. We still have concerns about the hearsay element of this representation made, and we understand that hearsay can be taken into account. But I've already made submissions surrounding that, but we still don't have, if we're going to look at this properly, anything in the petition that resembles anything like a statement of truth. Who are these people? What narrative was given to them 3 months after the application to say, please sign on this in this petition? And why didn't they come forward and make a representation of their own if it was such a concern? And there's nothing here before you, and you can only take into account what's before you today to say that the council actually has any authority to speak on behalf of the residents. So there's all sorts of unknowns here, which would suggest that very little weight should be given to this. And the point actually, it's I do need to make the point that the counter argument to the Thwaites argument that you presented, I never made that argument. I'm aware of that. I referred to Thwaites, but not that particular point. The point I made was that the Thwaites case does say that where there is no representations from responsible authorities, representations from what used to be called interested parties need an extra layer of evidence. That was the point I made. What you countered is something that a lot of lawyers do make as a point, but I didn't make that today. Although I stated generically, based on the guidance, not just Thwaites, but other cases as well, the need for evidence to justify licensing decision makings. It can't be purely common sense in these scenarios. So to summarise, what we were saying is there isn't evidence to justify a representation that has been made. And also, Thwaite says where there are no representations from responsible authorities, not only do they need some evidence, they need an extra layer of evidence. That was the point I was making.
Okay. Again, as you were speaking then, we obviously heard there's particular concerns about the parking in the street just across the road, which is permit parking. Would you agree to a condition being put on that all drivers are explicitly told they are not to park in that street? It's a permit parking area only in any event. So you only ask them to do something.
No, absolutely. I mean, we're probably duplicating legislation, but if it does alleviate the concerns of the decision makers today, we can certainly agree to a condition that drivers will be instructed not to park in resident permit bays. I hope that's of some assistance.
Okay, thank you. Chair, no further questions.
Okay, thank you. I believe, Simon, you can sum up, please.
What we normally do now is I stay back with the committee. We'll have a discussion as to what will go ahead in relation to this application. But I'm aware that there's another committee scheduled that these members sit on at 5 o'clock. So it may be that we are not able to conclude our deliberations. It may be that we can, right? So what we normally do is, let's just say we had all day. I'd stay back with the committee, we'd come to a decision, and then I would put that decision in some form of written decision. Or we could even, in some instances, we give the decision today, and I back it up with written reasons. Okay, obviously, any appeal runs from the date of those written that written decision. But I am aware that we've got 25 minutes before these members will have to go on to a different committee. So it may well be that we don't conclude this until tomorrow. Okay.
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 Yeah. Okay. But either way, you will be given written reasons. We'll come to a decision by tomorrow, and the applicant will be informed of that decision, the yes or no kind of thing. But the decision then will be backed up with reasons within the next couple of days. Okay. Okay. Thank you, Chair.
Thank you, Simon. So we'll. I'd like to thank all for attending the meeting, and we'll now close for Simon to give his legal opinions.
That's it, Chair. So basically, what I'll ask Councillor Jones to go. I'll ask Joe Baber, the licensed officer, to leave, and I'll stay back until we've come to a decision until 5, and then the other committee will come in. And if we've made a decision, I'll tell Jo, and she can relay it to the applicant. If not, it'll be tomorrow. Okay. Thank you, Chair.
Thank you, Simon. Thank you. Yeah, I now close the meeting. Thank you for your attendance.
Thank you.